I just want to thank everybody for being here. My name is Kristen Miller, I'm the Executive Director of the LBA. I really want to thank our city panel for being here. We all really felt like this was a very important conversation, not only for us to have as a legal community, but for us to have in our entire community. Obviously, there's been a great deal of discussion about this in General Assembly, and some of the conversations that we've had with some of these members of our group are that there are a lot of other things that need to come to the fore in this conversation that we don't feel like we're making here. So we just wanted to convene this panel of folks who've been working on this issue for a long time. They deal with it in and out every day, and we felt like they were the best folks to kind of give us a better view of what's going on with the cash bail system. And then of course, we also wanted to bring in our moderator, Bonnie Feldkamp, the opinion editor for the Courier-Journal. She's been very invested in this issue and thought she would be the perfect person to bring everything together for us and get the right answers from the right people. So without any further ado, Bonnie Feldkamp.
Hopefully it works. If it doesn't, you can hear me. Like she said, I'm Bonnie Feldkamp. I'm the opinion editor at the local Courier-Journal. And the first thing I want to do, I'm going to walk out here because I feel like I'm making you guys turn your head too much, is I would like to go down and each of you briefly introduce yourself and then tell us one thing that people get wrong about bail and the community should know. And I know it's difficult to narrow it down to one, but I would like to stop and give you one thing you would better understood about bail.
My name is Tom Layne. I serve as the elected Commonwealth attorney here in Jefferson County. The one thing I wish people would appreciate is that the purpose of bail is not punishment. And I think we'll probably echo that several times today. As a subcategory of that, black letter law about bail has not changed in the United States in the last 230 years. How we understand bail has changed.
Can we bring the mic down a little bit as you guys are sorry, can you pass that and make sure everybody was hearing anything?
Want to say all that again because I think you want to do it. Oh, we need to make sure. Start over.
You know, I have to correct myself. My name is Tom Layne, and I serve as the elected Commonwealth attorney here in Jefferson County. The one thing that I wish people would appreciate is the purpose of bail is not to punish. And in fact, black letter law in the last 230 years in the United States has not changed. What has changed is how we proceed.
Make sure that's on.
I'm not going to do it for you.
No.
Hi, I'm Cindy Reynolds. I'm an attorney, a former district court judge. I'm also now currently the president and CEO of the Louisville Urban League. And the one thing I wish people would recognize about bail is that it does punish poor people. So while it is not intended to be a punishment, it's actually for many in our country and in the city.
Hi, my name is Leo Smith. I'm with the Public Defender's Office. I've been there about 40 years now. I think people need to understand that the cash bail system is a pretty unfair system, and then a lot of people plead guilty, even when they're not guilty, simply to get out of jail. And unfortunately, it's the poor people that's happening.
I'm Judge Josephine, Layne, Buckner. I'm a district court judge. One of the things I wish people understood about bail is in regard to felonies in district court. When we're looking at bail, we look at a person's likelihood to return to court, but we also have to think about danger to the community. And of course, as judges, we see people as innocent until proven guilty, but we do have certain things that are brought in front of us. One of those is a criminal record. Another is the facts, the alleged facts, and we do have to look at those when we're considering that danger to the community. So I wish people just understood that though we see somebody as innocent until proven guilty, we do have to consider those facts.
All of that. When you're talking about assessing that bail, when in Kentucky is it ever, can you withhold bail? Somebody is super dangerous. Is that something that ever comes into play?
Now, I saw that on the questions, and I had never seen a no bail in my experience, 17 years prosecutor side, public defender side. And I haven't seen anything like that since I've been on the bench this August. So I thought maybe one of my colleagues might be a better fit for that question because I've never seen it.
Is there any protocol for that in the state of Kentucky?
Capital cases.
Capital cases, okay. And then my next question is going to be, both of you spoke about how bail tends to penalize before, but help me walk through what happens when you show up in court, because you're asked if you can afford an attorney, and how is that not a red flag to then have an assessment to pay, ability to pay hearing? How do you, so the law says that bail can't be excessive, but wealth is relative, so whether something or not is excessive is relative that certain individual wealth. So what happens in that courtroom to assess whether or not it's excessive for that individual who happens to be in front of you?
Briefly, I've noticed since I've been on the bench that a lot of people don't have a job at all. And because of the charges that they have and not having income currently, I'll appoint the public defender's office at that point. But it just seems like there's so many people in court that don't have jobs. The other items that we can consider assets, property, don't seem to come into play at my level.
Does anybody else want to comment on ability to pay and how that's assessed in the courtroom?
I'll jump in here. The one thing you had mentioned, you would think logically, if a judge determined that somebody's too poor to hire an attorney, that they would take that into account in terms of the issue of bail. I'm not so sure that is what happens, but I would think logically that somebody should do that.
I think, a lot of things in court are very, I don't know if we want to admit this, but they're very rote. They're very routine things. And so I think about the number of people. And I think when we have these conversations, I hope that it does not come across as any complete shifting of the blame, right? I mean, I get in these conversations with people go, well, people should just stop committing crimes. They should. I agree. Most people agree with that. We also understand that in our system, we have actually had people on death row and put people to death who were innocent. So if you know that that has happened, and these are people who have been before many courts and many judges and ultimately are ultimately found innocent, not just not guilty, but innocent. So you have to think that for some of these lesser offenses that there are people who are charged and they're innocent. And I think to Leo's point, when you have been in for 10 days, so yes, there is an assessment about whether or not you can afford an attorney. If you can't, a public defender is appointed, and that is the next time you will come to court. But in the meantime, somebody has to set a bond. And if you can't afford it, even if it's as little as $500, and honestly, there are a lot of $500 bonds being set in Jefferson County. They're not, for you and I, we could pay $500, and certainly we would pay it for our children especially, right? But then in that time, the next time you go to court, it's some offense, I don't know, possession of marijuana, you name the thing, we'll give you a deal, 10 days to serve, credit time served. It's very hard to pass that deal up when you've been in custody for 10 days. And that's what Leo is referring to when you say we're getting a lot of pleas of guilt from people who maybe, if they had the resources, would want to fight it. And I'm not saying everybody, but there are some. And if you are the one that gets that plea, squeezed out of you, I mean, it does really change your life. It does really change how you move forward. So, yeah, it does seem logical that folks who can't afford a lawyer also probably can't afford any kind of bail. And I don't know that we even have the data to show that setting a bond on them is actually, helping people to show back up, because we certainly have our share of no shows in Jefferson County for whatever reason. But I think as we have these conversations, and it's very important for us to have very holistic conversations and go ahead and bring up the things that people in the community are going to challenge us on, right? Even when the judge says there are so many people that are not working because of what I do, I can hear the corporations go, we have 1 million jobs open, why aren't people working? I'm like, and childcare is really tough right now. And bread costs more, and gas costs more. And so there are barriers in people's lives that those of us with the privilege of being in this room probably have either A, not experienced or never will again. And so I think we have to always put on these other hats as we really think about how to move forward with policy and policy changes.
You wanna speak on that?
I do, and I think just a little bit different angle. As I mentioned earlier, black letter law in the United States and Kentucky has not changed in 230 years. The US Constitution and Kentucky Constitution dealing with bail both say almost the same thing. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. What it doesn't say is that bail must be affordable. So the fact that somebody can't afford a $500 bail does not mean that it's excessive. And that's one of the things that a judge has to look when he or she is setting the bond, is the financial ability of that person to post bail. So I use this example. If an individual was charged with murder and they were a homeless individual and they had no resources at all, $1,000 bail would not be excessive, but it would not be affordable for that person. But if the richest man in the United States, who's worth $230 billion, killed somebody, and I set his bail at $10,000, somebody say, well, that's outrageous. His bail ought to be $10 million, $10 billion, because of his financial ability. So it is a scale that a lot of people don't appreciate, why you see the same charge, but different people have different bails. And sometimes it's their criminal history, as Judge Buckner said. You have to look to that factor. What's their history of coming back to court? So when we look at, and our rules also say that every offense is bailable before conviction, except for death as a possible punishment, and the proof is evident or the presumption is great the defendant is guilty. So even in a capital case where you cannot bail, there are restrictions as well. You have to be able to show that we're going to convict this person. I just can't go out and make the accusation and keep somebody in custody. So we have to be able to show that the evidence is great, not that, and whether that standard is clear and convincing or beyond a reasonable doubt, it doesn't say, but we have to be able to show that. So again, my point being, because it's not affordable does not mean it's excessive.
Help me understand that last part that you were talking about, because if bail is assessed prior to any evidence being put forth, how is that determined whether or not someone who said there's clear and convincing reasons?
Well, again, I'm not saying that's the standard. I'm just saying to say to a judge, you should hold this person without any bail at all. I'm going to have to put something in front of that judge to say this is why this is a case where the evidence is great. Unfortunately, the criminal rule of the Supreme Court don't define what that means. So it's a case by case with the judges who hear those cases.
Help us understand the next part, which is kind of goes from there, the risk assessment, how the judge receives that piece of paper that tells you about the person in front of you. Somebody talked to me about what that is that they get and how this grading system helps you identify how to set bail for an individual. I'll talk about that.
There are other people here who know more specifics, but I have risk assessments in files for cases that I have at court. But one of the things I've learned since being on the bench is on our call day, when we talk about people who are being held before they made it to an arraignment, like we review all the people who come through. And the pretrial services person will tell me if somebody's low, moderate, or high risk for returning to court. Not what their charges are, that's a separate number, but you kind of where they fall, if they have a record, do they have a history of not returning to court? And if they do, are their charges dangerous? Kind of a mix. It's a percentage that we actually get. And once that's read to us, because we're on the phone and they're calling. So in that moment, you're hearing a person's charges, what's charged, what their risk assessment is, and making a decision. And we understand that the goal is they're in jail and we need to make a fair decision. I think everybody takes that very seriously. But I think you'll notice from that bail determination, to them being in front of a district court judge and having a probable cause hearing evidence in our felony cases, you'll see a change in that bond because we have more information.
Those initial and then amendable.
Correct.
Does that require, your defense to request that the bail be adjusted, or is that something completely separate? Because I know that they'll go back and they'll say, well, that's too much, and then negotiate.
I mean, it's a standard motion that's made at a probable cause hearing. It's, I have never been to one where it wasn't made unless there's been some discussion for something else to happen that I'm not privy to. But I go back and forth because I feel like it's a lot of information that's given to us to review when those people are coming into the jail. They've been in front of that pretrial services person. We have a lot to review, but it's never gonna be enough because it's not in front of a jury and with all the pertinent, relevant information being brought out.
Sure.
But I think we really do make an effort to make those bonds fair.
Part of the problem though, in risk assessments, even if you come down on a low risk assessment, oftentimes the judge override that. And there's been articles and studies, and you look in various counties, you've got some counties where an extremely high percentage where a judge will release somebody on the low. Then you've got other counties just the opposite. So that's just another problem with the system, the way we've got it set up, where you live can make a big difference. As well as within that community, that even though you like to think everybody's the same, the fact of life is that some judges will follow the low recommendation because others that will override.
And the other thing, and I think you all correct me if I'm wrong, but when you are doing the risk assessment, you get scored for whether or not they could reach the number is that still true or no? There's some, so they don't do that at all. So there was a time, right? Was there a time? Okay, good. So that's good because we can improve, we can change, but just think about it. You know, whether or not they could reach the person that you listed as your next of kin. And so that had to be changed. So I think as we think through what we're doing, we should be feeling good that some things have changed even ever so slightly, and hopefully we can get more changes because we can see how that would certainly impact people depending on wealth, even depending on whether or not they had cell phones or not at the time, those kinds of things. So those are the things I think we have to think of. We certainly want to make sure the public is safe, but also ensure that we really are at every step, I think, making sure that there is some sort of justice and access to it.
Standard, I'm sorry, you could.
Well, because Ms. Reynolds really hit on an important point. Kentucky did use a pretrial service model that penalized people for all sorts of silly things, that they didn't have a phone, they didn't have a job, they didn't have a regular residence, none of which meant they weren't going to come back to court. In 2012, right, as I was elected Commonwealth attorney, the Arnold Foundation came to us with a proposal for a risk assessment tool. And I know Michael Connell, who was the county attorney, and we all agreed we wanted to see how that would work because it was going to change how we assess risk. And it took variables, 9 variables that they've used. And Kentucky had some of the best, which is always hard to believe, that Kentucky had some of the best records possible to validate this tool. And so they came up with these, and they came up with a scale of 1 to 9. And if you're 1 to 3, you're low risk, you're good chance to be out. And so we used that risk assessment tool starting in 2013 with pretty good results. About 2 years later, they revalidated the tool with all the information they had, and it confirmed that people who are being released using this as a tool, and that's important. Judges didn't want to be told what to do, but it's a tool. You know, I can take a hammer and nail in 2 ways. I can use a hammer or I can use my hand. One of them's going to work out real well, the other's not. So rather than just relying on the judge's gut feeling, we said, here's the tool. And that tool gave them some help. Now we got a new problem. And we found that the risk assessment tools may have flaws in as well because they are based in part on prior criminal history. And if people were arrested in the past that should have been arrested, we now have a tool that's out of kilter. So they're going back to look at that. And again, like I said, what we look at in terms of bails and how we look at our opinions have changed, our process has changed, but the law has been pretty clear as to what's supposed to be done. So the risk assessment tool is better than what we had, you're absolutely right, Ms. Reynolds, better than what we had, but not as good as what we need.
And the other part of just understanding how bail is assessed that I wanted to get at is talk to me about the severity of the offense, how that plays in. So if somebody comes in and let's say, oh, drug possession is X, and then but armed robbery is automatically in this bracket, is it that simple, or how is that understood when you walk into a courtroom?
Well, I think the type of the charge, for sure, the judges will take that into account. But the difficulty here is you gotta keep in mind that people are presumed innocent also. You can be accused of some very serious crimes, and as Ms. Reynolds has already pointed out, we know without a doubt with the DNA over the last few years that there are people that have been exonerated that spent enormous amounts of time in jail or prisons, and people obviously that had been executed that were innocent. And so we've got to be very careful here. Simply because you're accused of something, even when it's very serious, does not mean that you did do the crime, and you got to factor that in terms of what the bail ought to be. Because otherwise you run into what I talked about earlier. You incarcerate people who haven't been convicted, and they're really sweated in terms of willing to plead guilty. The longer you stay in, you lose your job, you lose your family, you lose schooling, you lose all kinds of things. So people are more apt to plead guilty oftentimes, but they haven't done what they're accused of, or they may have done something, but they've been overcharged. So we run into that a lot. So we have to be careful.
And this other little thing, sometimes your car is impounded and there are daily charges for that. And I mean, there are things that happen when you get arrested that we don't even think about. And so just thinking of some of the unintended consequences as well, I think just the financial burden of the 5 days, the 10 days, the 7 days, whatever, waiting in custody and what you lose and what you don't have access to on the other side of that.
And those downstream effects. So we're talking with your housing, with your children, with your car. What else am I not thinking of as far as downstream effects to being
You lose your family, you lose custody of your children.
And there have been studies done. I served on a board of directors of a national group, the Pretrial Justice Institute, and they had a project called 3 Days Count. That is, in few as 3 days, all those things that you just described can happen. Let me say this, and again, a little bit different angle here because I wouldn't be much of a prosecutor if I didn't say this. Yes, there are people sometimes who are accused who didn't commit the crime. Yes, there are people sometimes who are overcharged. And yes, there are sometimes people who committed the crime and are charged properly or convicted properly. So we don't want to throw out the baby with the bathwater and say, well, nobody should be held because of the risk that somebody may have been falsely held. At the same time, we've all heard the adage, it's better that 99 go free than one guilty person be convicted. I mean, 99 guilty go free than one innocent person be convicted. And I mentioned to you earlier about how we think about it. In 1966, the presumption across the country was a presumption of release. We felt it was better for people to be turned loose than to be held. And then that changed in 1984 when our thought process has shifted to it was all about safety and dangerousness. We felt it was better.
What prompted that flip?
It's because, well, I don't blame any political party or anything, but things just happened in 1984 and before that didn't happen. So the process changed. So now we're in the third wave. And that is what we're talking about here today. The fact that you're poor, are you being penalized because you can't post bail? And do you have a third party post that bail for you? Does grandma come in? Does your best friend come in? Does a nonprofit come in? So we're kind of in the third wave now of how we think about bail.
And what are we? One thing that comes to mind is how we handle addiction in our communities, and how, when you think about somebody coming in, is it in the judge's mind of maybe they need to detox for a few days, so we're gonna have that go into play? Are we relying on a system in our courtroom instead of the social services that we need to be for our community to close some of these gaps? Does that make sense? That actually makes sense. They speak to that.
I think there's definitely an over-reliance on police and the justice system for people who really do need social service support. I mean, the answer to that is overwhelmingly, in my mind, yes. I think that we have not trained officers to deal with the amount of mental illness that's happening in our community. And particularly now, given the pandemic, we have, I think about the 6,000 homeless children before the pandemic, and then what is happening now, even as we speak. And all of the stress and mental health issues, we all know, anxiety is up something like 600%, suicide is up, depression is up, and there are consequences to that. And no one is really talking about increasing any sort of investment in those resources. And so the number of people who are actually ending up in jail, who should really be in a hospital somewhere getting some kind of treatment, is really criminal. And we are, and I think police are faced with a tough thing. In some cases, you have someone calling police and saying, this person is doing whatever, they're trying to respond. The question for me is, where should police have to take them if you do have to intervene? What should happen? And I thought about this, especially with the last death in our jail that really happened at insane almost. So I want to know, was the person using, were they under the influence on the way to the jail? Did something happen the minute they crossed the threshold at the jail? Who is doing the assessment, and who has the capability to actually do a good assessment? And why aren't we having this conversation and talking about the real impact of mental health and the lack of resource in our community and across the country? I mean, because that is a part of it. I'd say, I don't know, the numbers are maybe more than 60% of folks that are in custody have mental health issues that are not being addressed. They're certainly not going to be addressed in a jail, and there's no jail that's not overcrowded. There's no jail that's not overcrowded. We are talking now about our jail numbers. I think they are at an all-time low, but I have asked this question. When we talk about the jail numbers being low, are we remembering the days when we counted those numbers and we had another place? We had CCC. So if the numbers are the same and we've only got one facility, the jail numbers are not low, particularly when you have staffing shortages, particularly when you don't have the right staff in place, because the guard is not a mental health worker. That is different. And so we've really got to have more holistic conversations. We can't keep siloing these things because we're not moving the needle fast enough. And innocent people are dying. And they might be guilty of something. I bet all of you all are. I bet somebody did some speeding on the way here or something. Some people get caught and some don't. But we can't just throw people away. And because I love what Tom Lyon said, and that's amazing, by the way. Just know what you think about, even in a capital case where you have the ability to set a bond, there's still other conditions. So I thank the Bar Association for the conversation, and I hope we can do more and tie this to other things and how we really are treating people who really are in need in our city.
Anybody else want to add something before I go on to my next question?
Well, I did want to say, and Leo Smith,
She said-
well, yeah, I can shut up on the head. Well, we go back a long way now. If we agreed on everything, there'd be something wrong.
We need counseling. And we'll have that.
And Leo Smith and I serve as co-chairs of the Jail Policy Committee, and Leo will correct me if I'm wrong on this, but we had some numbers yesterday. And the current population of the physical building is yesterday was 1,339, which is below the capacity of that building. Before that, we would talk about 1,793 as being capacity because we had CCC where we put people in work release. So we are currently below, and what they pointed out yesterday was 70% of the people who are incarcerated on felony charges in circuit court. The other 30% are in district court, either waiting for a resolution of their misdemeanors or hearings on their felonies to waive it up. And a very small percentage, in fact, they had, if I recall correctly, one person on a $500 bond yesterday. Now that could be different today because this is a snapshot of yesterday. It could be 10 today on a $500 bond. But the point I want to make is, we have worked hard, our whole community has worked hard, and it's, thank goodness we have people like Ms. Reynolds who are kind of like that little burr under your seat who are saying you're not doing enough. That's a good thing, but we are also working hard, and we have made changes, and we still need to make changes. I mean, you're right, being in jail, that's why our rocket doctor, our heroin rocket doctor, we we're in partnership with the county attorney's office. The goal was to get people arrested on drug charges into treatment within 30 days. Because every day they're out of treatment and they're out on the streets waiting for a disposition of their cases, another day to reuse or reoffend, and if they reuse, the possibility of overdosing. So we recognize that, and we have tried to do that, and I think it's made a difference. But then COVID hit, and what we could do in 30 days, now they're being passed 60, 90, even longer days, which meant those people weren't getting the treatment they needed, which meant a lot of them reoffended or died, unfortunately. So COVID, I know you got a question on that.
I do, thank you for that segue, that's exactly what I want to talk about next, is what do we learn from the pandemic? Administrative release orders that were put in place, and how can that help us shape bail reform? Because we now have a year of data around this administrative release. So talk to me about that, what have we learned and what can we take from that?
What we have learned is that people who have been released on some cash or financial conditions, property, non-financial conditions, we're coming back to court at about 88% of the time to 92%, and we're not reoffending 88 to 92% of the time. And people who were administratively released are released on their own recognizance, almost identical numbers. So what we were showing, what we showed, the whole argument about is when you have skin in the game, that's when you come back, doesn't hold water. People were coming back because that's what they were supposed to do. So they are returning without having cash bail posted for them, without having non-financial conditions. And administrative release showed that. Now that's on minor offenses, but that's where the worry is if you have somebody in jail on a minor offense. So it works, and that's one thing that COVID taught us.
On the administrative, I agree with Tom as far as the administrative release. It's pretty clear that there are a large group of individuals that you actually can release and just promise to come back, which we have not been doing, and COVID did help show that. One other thing I'd like to throw here though in the mix, it is a true statement that the numbers are down in the one facility, and a lot of people have worked very hard, but we also got to keep in mind where we come from. I mean, in terms of, we've been in a bad situation in terms of a lot of people incarcerated that shouldn't have been. So we got to make sure that we keep these gains, and we need more. For example, currently, unless something has changed here recently, we're not allowing people, for example, work release. So in the past, we've had a situation where work release, and there's a lot of jobs as industry will tell you right now, where we would allow people out, but we're not allowing that now. There were a lot of different types of releases, which again, I don't think that that's changed here. And it's something that we ought to be looking at.
And that's when you leave during the day for work, which you report back to jail and anything, right?
Sure, exactly. So obviously, the longer you stay in custody and you don't have those kind of contacts, a job, et cetera, and that, the statistics show you're more likely to get rearrested. There's no doubt about this. So the longer period of time, we're really shooting ourselves in the foot in a lot of ways, because we're going to have to deal with the problem sooner or later. So if somebody is going to serve time on some of these misdemeanors, for example, it makes more sense to allow them, depending on the amount of time, et cetera, and that, but to allow them to go out, say, on work release, where when they get out, they're already going to have something set up. They're going to be able to support their dependents. And if they owe restitution, they're in a better position to do that. But we're currently not doing that, and we ought to do that. So
And
that's
that's
a lot of
moved
things.
because of worry about spreading the virus, right? So that's the thought behind it, that it was taken out of play for that reason?
Well, that's one. Now, the jail has had to deal with staffing issues for sure. But that is, the idea was if you let them out, they may bring the virus in. But that really doesn't make sense, because the persons that work there leave and come back, and they're just as likely to bring it into the institution as somebody who's incarcerated. And with the testing, they're very good as far as over at the jail, offering the testing, by using things like that, you can do it safely. But that's something that we really have not been looking at, that we ought to be looking at.
Yeah, and that argument does fall flat too, when you think about people who are constantly entering the jail. You know, if they get picked up, they're entering, and so, you know, you hate to think that there are these things that could be so much better for our community that we're not doing because they may, you know, stretch us. If we could get some of these folks out of custody, reduce the numbers, and hopefully return to work release, you know, they wouldn't have as many people to have to monitor during the day, you know, people will go in and come out, and so we've got to make sure we as a community are really pushing for those releases to happen again. I think it's extremely important. And I also think that in any industry, we all have learned things in this pandemic. We all have figured out how to do things virtually, how to, whatever, we've improved in many ways. Now, there are lots of challenges, but it would be a shame for our court system, for our judicial system, for our jail system, not to hold on to the things that we found good and help and improve upon those things. So, you know, whatever we did to release people from custody when we were at the top of the pandemic, we really got to think about continuing to do those emergency things if they work. And particularly when you hear these kind of numbers from both sides of me, there's no reason not to continue and to move forward in that way. And I want to say this, there's always the fear that judges have that they are going to be blamed if someone that they have released from custody goes out and commits another crime. And in fact, we recently had someone, a pretty high-ranking official, I think, say about a council person that he should be jailed for suggesting that we should use community dollars to bail people out of jail. And that's the fear. That's the fear that everybody has. And if you, as the judge, you ROR someone because, you know, it was a bad check case. Yes, their second one, they're low risk. I mean, even if they're worse, this is what they've done. They're not out there beating people up or killing people. You ROR them and then they go and they actually do the armed robbery or whatever. And so what happens to your career? I mean, those are things that I don't care what anybody tells you. They do consider those things. I think that most do. We shouldn't, but the world, people are real, they're human, and you can't, it's the same way we say, whatever bias you have in your life, you have them at work too. Crossing the threshold to go to your office, putting on your hat that says I'm Michael O'Connell, county attorney, whatever prejudice, whatever bias people have, you have those. Sorry to use you, Mike, Sadiq, I'll use myself. You know, but we all have them. And so, and I think the more we understand about that, the better we can be at creating policies that really are equitable and make sense across the board.
Judge Buckner, do you have anything to add about what we learned from COVID-19?
These discussions are really good. Because when we are actually making the decision, all of the things that we talk about go through our minds. And, you know, we want to end up on the side of fairness. We want to know that we're doing the right thing and making the right call. You know, as Sadiq just said, we can't be held responsible for what people do in the future, but we have to make a decision, do our job on what's in front of us at the time. And I just think constantly getting education, making changes, trying new things is the way we get to that end. But we have to all be willing to try new things and try other things and, you know, not stop what works. That's all I would add. Also, just one little thing you mentioned earlier in a question.
Sure.
About judges saying maybe they need to stay in and drive.
Right.
You used to hear that years ago from judges, but in the training and as I sit there now for the last 6 months, I haven't heard anything like that. There's a totally different picture of addiction.
I lost my train of thought. Well, you know, I think this is what I want to make sure we understand. Some of these conversations happening in this city and in other places around bail are really because poor people are beginning to figure out ways to get their hands on bail. Most folks didn't have a problem when the middle class and the wealthy were able to post bail. No one was talking about it. there were crimes committed, people got out, well, maybe sometimes you get a hit in the paper, but this with social media, and I think with what has happened here recently, there's a lot of talk about who gets to access what. And I think we also have to be honest about that. There's some bias even in the conversation and when it actually bubbles to the top. This is really, I think, a conversation around poverty too, and it can't be ignored. So what these third parties are allowing to happen, if you think about the Bail Project or any others that do that, and I represent a nonprofit, we don't post bail for anybody, but I understand that there are others that do, and I understand why, particularly now, given what we see that is happening in our jail. And we have had, what, 6 or 7 deaths now, pretty recent. And so people are bonding people out, and all of a sudden legislators are saying, we don't want that, we don't want you. And they're not talking about rich kids getting bonded out, because that would be an issue with their parents. So when you begin to target nonprofits that are doing that kind of work, let's be clear, we're not targeting the nonprofits, you are targeting poor people who don't have any other resources. And so we just need to be honest about what the conversation really should be.
I wanted to talk about, real quick, you triggered a thought, is there's a presumption to, I think, in the community that I like to clear up, is that when you're out on bail, you just walk the streets and you're fine. Let's talk about the criteria around bail when you are released on bail. There are still certain criteria you have to meet while you're on bail. I think we saw that recently when someone was bailed out, that they're like, oh, they're just gonna let them out and he did X, Y, and Z. And it's like, well, it's not, you didn't just stroll down Main Street. So talk to me about that. What are those criteria and parameters set up when someone does bail?
What I can think of right off is we ask that they have no new offenses, they have no contact with a prosecuting witness, if that's the case, no contact with a place of violation, whether that's stealing or domestic or whatever it may be. And if there's a gun involved or other weapon, not to possess that gun or weapon while they're on this particular bond.
And can they go from bail to house arrest? Can that be a criteria where, yes, you can go out of physical jail, but you're gonna go under house arrest now? Is that happening?
We do a lot of HIP now. It's
HIP for-
a home incarceration program, whether that's with a cash bail or just HIP. I'm surprised by the amount of people who are on HIP now, because that used to be such a rare occasion years ago, and now it's a standard with their work releases or even searching for a job, whatever the case may be. But I think the most attention what we're paying the most attention to is making sure that the person on the other side is protected until we figure out what's going on with the case. So that no contact with places and people is very important, and to have no new offenses.
This way, that's
Well, I do want to say that by our rules, the Supreme Court rules and by statutes, judges are supposed to release people on their own recognizance, which means no conditions, no money, with the presumption that they're going to come back to court and follow and stay out of trouble. The second thing a judge can do is impose non-financial conditions and say, okay, stay away from the store, stay away from your girlfriend, whatever that is. A judge could ask a third party to be a signatory on a bond without actually posting, but saying, I'll put up the money if they don't come back to court, which actually goes all the way back to the Middle Ages in England, because if you didn't come back to court, the money that was put up went to the person who suffered a loss. So it was a win-win. Somebody didn't come back to court, they ended up getting caught and they had to stay in jail, and somebody didn't come back to court and somebody got rewarded. The third one is, or fourth one rather, is when we get to the actual bail, and that's when the judge sets an amount of bail that they expect that person reasonably would be able to post. That's what the case law says, reasonably able to post. And Buckner raises an interesting question about why there's so much HIP. Well, in the mid-90s, we changed a rule. You used to not get credit for HIP. So if you were on HIP and you screwed up, you got convicted, you served your time. Now, when you're on HIP and you get convicted, the first thing they say is, okay, he was on HIP for 2 years, so he gets 2 years jail time credit, which comes off the sentence. So every lawyer likes to see their client, particularly the COVID situation now, because their clients are getting all this credit, and when you finally get your sentence, they say, well, he's already served a sentence. And so that's why there's so much more HIP now than it was back in the 90s when we first started HIP.
And I just have a question about HIP. Is that free?
No. No, you have to pay for it, which of course puts more
I know the case stage.
The other thing you have to keep in mind with HIP, and I don't disagree with what Tom was saying, but one thing you have to keep in mind, most people don't want to be on HIP. I mean, there's still a lot of restrictions put on it. So it's not like it's a, it's an easy thing. Don't get me wrong. If you gave somebody a choice between staying at home and staying in jail, I think they would choose staying at home. But there are restrictions on your liberty. So it's not like it's a free ride and you can get and you do get this credit now, which of course is good. But very few clients that I've had represented over the years have asked to add that if they could otherwise get out. And so that's not so we got to be careful too. We don't want HIP numbers going up pretty high and then it looks like we're doing something about the problem, and we're simply putting people in that otherwise should not have any conditions on them. So you do have to be careful, and as Ms. Reynolds pointed out, it does cost money in the program. So that makes it difficult for people.
It costs money, and it opens your home up to law enforcement coming in, and it's not that people don't want, or everybody's not doing something illegal in their house, but it does open the family up to a level of scrutiny that otherwise they wouldn't be subjected to. So again, I think we have to talk holistically, but it's so wonderful to sit with people who seem to me to want to convert, change, somehow reform Kentucky's bail system. I mean, when you've got the prosecutor and the public defender and the judge here, I mean, we should just do it. Just need to work.
We're having a little bit up here, it's great.
We have a couple of questions from the audience. Kristen, do you want to read those or do you want me to?
I didn't hear my shape. The first question we had was, can anyone speak to the living room program that has been defunded?
It's gone.
Yeah.
It's gone.
I guess that's it.
Part of the problem, there weren't enough people being taken into the program.
Can you tell us a little bit about what that, for folks who may be watching online are familiar with what that program was, what it tried to do, and what happened to it?
Well, it's similar to what Ms. Reynolds was just saying a moment ago about people who are already stressed out and they've got mental health issues and drug addiction and their dual diagnosis, all sorts of things going wrong in their life. And then you pick them up for some crime and you put them in jail as if though that's not a stressful environment. So the hope was by putting them into a quote living room, a facility not part of the jail complex, that would give them a chance to calm down and figure out, somebody would be there to counsel with them and help. But I think part of the problem is we just didn't have enough people that qualified for that program. Mike, you're better on that than I am, but it looks good on paper, but actually getting the right people in there is another issue. Now, and I just read in the paper today, and you're probably more familiar with this than I am, but Louisville's going to try this again. They're going to try to say on these 911 calls, instead of sending the police, or if the police get there, let them immediately call for social workers, counselors to come in and address the situation, instead of expecting these officers to do it, which they're not trained for. And it's not so much their fault either. I mean, if you're not trained, that goes 2-3 steps beyond the officer. If you're not trained to do something, you're not trained how to shoot a gun, whose fault is that? Who failed to train? Who made the policies? So those are all things that you have to look at. So that's where the Living Room Project is. Mike said it's gone.
Well, there's another with the LEAD program, law enforcement assisted diversion, and I think that's had modest success as well. But they were all based on models and programs around the country that were good. but it just is a human process, and COVID didn't help.
But the
I'd like to say something here.
Okay.
Before we leave.
Let me say this on this issue though. The only thing that this country has really been consistently willing to invest in, and this is important, the living room, there's some, you get a year, you get 2 years, and then, okay, we stop it. The LEAD program, you get a little while, well, it's not being, we stop it. But policing and jail, we just keep funding, we keep funding. But when there are other things that really would help to reduce some of the workload on police officers, reduce the numbers in jail, really deal with the root cause of it. You cannot separate homelessness and poverty from desperation. That you cannot continue to push down constantly. And you have to admit that the systems are racist. Many, and I'm not saying the people, I'm saying the systems. They are working in the way that they were designed to work for the people they were designed for. 20 years ago, I wrote an article, which I wish somebody would find here at the Bar Association, to talk about some of the crimes that were causing people to be disenfranchised. I mean, there were white people who said, hey, wait a minute, this is impacting us. Let's look at some different crimes that are impacting different people, and there's a history there. So those of us who have gone to the trouble of going to law school, undergraduate school and then law school, getting these higher degrees, have an obligation to raise some of these issues in our community. It is not enough for us to push for status quo when we know there's data and ways to do things better. So I think our push should be what Michael Connell, I think, is leading to. When you have a program like the Living Room, you have to be willing to stick with it longer. You cannot just back away from these things after a year or two. It just doesn't work that way. Go ahead, Mike, I'm sorry. You want this, Mike?
I wanted to inject something in this conversation that hasn't been mentioned yet.
Sure.
Going on the other far end of the spectrum, Judge Reynolds said, I'll often quote this Mark Aurelius, who ruled Rome from 160 to 180 a few years ago, said that poverty is the mother of crime. So that's not a new, you're absolutely right. That's the other side of the equation on how do we get to where we are. But there's been no discussion yet today about cashless bail system. And I am wholly in favor of that. And it would take probably a constitutional amendment in Kentucky to accomplish it. But that, those in the room that are familiar with it, people are detained, that there's a motion made by the government, evidence is presented pre-trial, there is a judicial decision whether or not a person should be detained or not detained, period. If they are detained until the matter is concluded, period. Takes money out of the equation, okay? And it takes work, effort, and all those other things to do. That's the current federal system, okay? But the criticism and the targeting of legislation with respect to posting data is just an approach at a symptom of something rather than something long-term that has true benefit how we handle this. Tom Leo said, and these figures have been going around, this is no secret, that people who are released on their own recognizance, people who are released on bail, people who get out of the bail project, there's an 88 to 92% return rate. So
Let me ask you this. So, first, when you answer this, can you give your name so the people watching know who you are?
my name is Michael Connell, I'm Jefferson County attorney, and we do a lot of this stuff.
Wonderful. So, the pushback on the federal system that I read was people were saying that more people would end up in jail than there are now if we went to that system. So tell me how I'm wrong or how I'm right, and let's talk about it.
Well, I'm sure the data, I don't know what you're referring to, you said people say that, but, Tom, if you want to take a shot at it.
So let me say that other states have started. One of the most recent is New Jersey in 2018 went to no cash bail system. Their crime rate did not go up. The number of people not coming back to court didn't go up. And what happens is the detention hearing that Mike refers to is that a prosecutor makes an argument and has to present clear and convincing evidence that this person is a risk to the community, that they would not return, and that no amount of cash is going to make the community safe. 50% of the time that those motions have been made, the judges have denied them. So judges are not rubber stamps for the prosecutors, they're denying those motions, and their populations have not gone up, their crime has not gone up. So New Jersey is one example. I believe New Mexico, California's got theirs all tied up right now in litigation. Illinois went no cash bail. The District of Columbia is no cash bail. It's going on around the country. And what I again want to point out, Kentucky was a leader. We did away with bail bondsmen, a for-profit pariah that took money from people and never gave it back to letting the court hold the bail and give you all but about $10 back. We went to the new risk assessment tool, which has its flaw, but it was better. So Kentucky has always been kind of in the forefront, whether we liked it or not. We were making changes, and the rest of the country's like, how do you do that? We've got a statewide pretrial services that most states don't have. We have a unified judicial system that most states don't have. So we're very progressive in a lot of ways. And the fact that we can have these discussions says a lot for our local community as well. And we need not to let personal issues and things that may have happened, and I don't mean us, we don't have personal issues, we're good. But for some of us, there are some personal issues, and we just say, we're just not gonna do it because I don't like you. We've got to get beyond that, and if we do, we're gonna have a safer community in the long run.
And what I'm saying is, and another thing to add to that, agree with everything that was said, and in the middle of us trying to be progressive really and get to a place of maybe a cashless bail system, our legislators are attacking the system we have and making it harder for people to get out in the face of data that does not support what they're doing. And that is where we have to use our voices as attorneys, as county attorneys and Commonwealth attorneys. Those Frankfurt folks need to hear from us that we don't want this. What they are trying to do is not going to keep our community safer. And I think it's important for us to really be able to say that. And I want to say too, and Kentucky does this, we may be progressive and have been at some point, but the systems across the country are so bad that it doesn't take much to be great when everything is bad. I mean, and so what I worry about with a detain or not, I worry about who and who makes those decisions, obviously judges. I worry about the impact racially, because there is a racial fairness committee in this state, and we see the data around what happens. You know, we think about what's happening with poor people. So I think we always have to keep those things in mind. Certainly a cash bail system would be a better system. Not quite sure ready to model it completely after the federal system, but close. So I appreciate the comment.
The details are gonna make a big difference there. For example, if I can just throw it in the mix, I do think that the cash system is a bad system. We need to make changes, but we gotta be careful what we go to. For example, if we go to this detention system that's been described, we need to have a real speedy trial, right? I mean, we really don't have a speedy trial right now, but otherwise we're gonna be in a situation where those people who are presumed innocent and may be accused of something very seriously, that are just gonna sit. So the details are gonna make a huge difference as to what we go to. So we do need to make change, but we gotta be careful in terms as to what change we make.
Judge Buckner, do you want to comment on the cash bail versus the federal system? Yeah. Yes, we've got a couple, we have one more here, we have a couple of hands raised here.
We'll take one from the crowd. We'll come
Okay,
back.
sure.
Hi, I'm Kate Crosby. Thank you all very much for being here. I think I know the answer to this question, but are there studies and evidence to show that a defendant's rates correlates with judges' decisions to, for example, override risk assessments or deny or grant detention in a cashless bail system? Are you aware of studies that show that?
I am not, but I can't tell you that there is.
Okay.
I have to imagine we study everything,
Right.
the size of your little finger. But one of the most recent that Leo's referred to, and I think it's important people to understand, he kind of mentioned this, in-person appearances are so important. There's clearly a difference when a judge sets bail in a case and he sees a person on a screen, and he or she sees the person
Right,
in person.
right,
So we know that makes a difference.
Right.
And as Ms. Judge Reynolds said, we all have inherent biases.
yeah,
It's a reality. It's what do you do with them?
right,
How do you recognize them, number one, and then you work to overcome that. So if a judge has a bias and the statistics show that, the data shows that, there's a bigger problem that they've got that far, they have to rely on statistics. So
Right.
we have to work to overcome those inherent biases.
What was the other question coming up?
Yeah, one of the other questions we got online was in regards to your comments about getting treatment for folks within 30-day period with the Rocky docket. Their comment was, even 30 days seems a little bit long. So what are those barriers that you're experiencing in trying to get treatment for folks, regardless whether it was at the 30-day level or even now when we're talking about 60 to 90?
The biggest barrier, respectfully, is the court shutting down. I mean, when you had an arraignment and then you could pass the case for 10 days or 20 days or 30, whatever it was, to come back with a treatment plan, and then you had follow-up 30 days after that to make sure they were following through the treatment plan, that gave us an opportunity, I believe, to help save some lives. But once we shut down our courts and we extended these dates way out, that created a huge problem. And the other factor is, we're probably seeing, it's something we didn't talk about, our arrest numbers in 2010 were about 41,000 per year, 2010. It has steadily dropped, but the last 3 years, partly because of COVID, we're at about 16,500 arrests. So a lot of people aren't being arrested, which means there are fewer people in jail, but some of those people who got arrested because they were using drugs, we may have saved their life. Not because they should not have been kept in jail. I'm not saying that the jail is a good rehab center, but maybe we were able to identify problems if someone was arrested and they were out on the street doing something wrong. Now we don't see that enough. So our overdose deaths have gone way up in Jefferson County. Our suicide rates have gone way up in Jefferson County. That general population, when you put them into the jail, you're going to see the same numbers. That's why I think you see suicides going up and overdoses going up. And as Ms. Reynolds said, did it happen on the way in? Did they pop something in their mouth because they wanted to hide it? So there was a problem. That's why the rocket docket for heroin cases has been hurt the most, is not being able to get a quick hearing and a follow-up quick hearing. You got some questions?
Yes.
Thank you, Jennifer Clyer. Thank you for being here today. I'm a former public defender, now in private practice. Our LBA president, Seth Gladstein, who's here today, wrote a recent editorial for the Courier-Journal, I believe, on appropriately funding the judicial system in Kentucky. Can you speak to how important that is to actually being able to make changes to the cash bail system and then actually effectuate them? For instance, Leo just talked about the right to a speedy trial. That's wonderful, but if you don't have enough attorneys to actually be able to properly prepare to have a speedy trial, then what's the point? So can you speak to the correlation between those two issues?
Well, I don't think there's any question about it, that we do need appropriate funding, you need more prosecutors, you need more defense attorneys. And you've got to have a willingness, obviously, to put the time in, which I think everybody's willing to do that, but everybody is stretched right now in terms of staffing issues. And so that certainly makes a difference. Getting back to the detained, if you're going to keep somebody who has no opportunity to get out, at a minimum, we've got to move the system along and give priority to those cases, and got to be willing to try those cases if that we're not able to resolve them. Otherwise, people are going to sit in, and again, it's probably still going to end up being the court, even though we say that we moved away from the cashless system, because individuals who aren't poor probably have other things that judges or others, and not intentionally, would be taking into account, but very well may influence their decisions.
I just want to tell you, asked a question in the white shirt about race, and so I just did a little Google search. Direct racial discrimination, evidence of direct racial discrimination in sentencing, evidence of direct discrimination at the federal level being more prominent than at the state level. So I would imagine that goes throughout. Blacks more likely to be disadvantaged in terms of sentence lift at the federal level. So again, that's back to that system we're talking about. Latinos more likely to be disadvantaged in terms of the decision to incarcerate. Young Black and Latino males tend to be sentenced more severely than comparably situated white males. Unemployed Black males tend to be sentenced more severely than similarly situated white males. It goes on and on. So there is evidence throughout the system of race being a factor always. There's no place where race is not a factor, and I would also think poverty as well. So it doesn't take a lot of research to find studies that will show it. So those are the things that we always have to have in mind, I think, as we plan for what we do next.
We have neglected our judicial system and our criminal justice system for so many years that I can't remember to the contrary. I've got about a year on Leo in this process, and I can tell you that we do the greatest job of training prosecutors, public defenders, lab people, and then what happens after we train them? They go out in private practice. The lab people go over to Indiana. We train them, they go to Indiana, make $10,000 more. So that's why it takes almost a year now to get back DNA evidence. 3 to 4 months to get back evidence about drugs. What type of drugs do you have? You can't have a speedy trial right if you can't, and then so for good cause, a judge can continue the case beyond the 180 days of trial. Well, what's good cause? The judge is in trial already. Good cause. We indicted 3,000 cases last year. We tried, well, because of the COVID, we tried 35, but normally we try about 80. You got about as many civil cases. How many cases can a judge try in a year? Our system is, we need more, and I know people hate to hear that, but it is breaking down under the weight. The clerk's office is like 20% vacancies right now. They're getting people in that are barely making enough to avoid being on public assistance. And they keep saying, oh, well, you know, just do more, do more, do more. With what? We paid jurors the same amount since 1976, $12.50. And every time we went back to the legislators and said, you need to increase jury pay, we'll never pay them what they're worth. Some of you are making $200 a day. We're not gonna pay them $200. But at least at $12.50, I can't get a hot dog and a soft drink, much less pay for my parking. And you know what the legislators told us? It's their civic duty. Well, I'm sorry, how many times have you raised your fees, your pay since 1976? What about your civic duty? So that's the problem. They want to keep strangling it. I'm sorry, I get to Rob.
We lost 36% of our employees in the child support section because they're making less money than they can make anywhere in the county. Okay, we've lost, Ingrid, you could speak to the exactly, we've lost more prosecutors and public defenders in our office than you can imagine. The turnover rate, these are good people too. We lose good people, the ones that do look at things properly, the ones that have that sense of, that inner sense of what's right and wrong, out the door. Because you can't pay them, they graduate from law school, they're steeped in debt, we can't pay them enough so that they can basically have a decent living and then with a family, right? Anyway, it's very shameful.
And to the point of the jury pay, it is a discriminatory system because who can afford to serve on jury duty? The person who has the job that is going to pay them, they can take a vacation day or a personal day, or they can say they're working from home and kind of work while they're waiting in the room. But the guy who's working an hourly job, who is gonna not be able to work, and then come in and gets $12.50, when you get in there and you start questioning them about serving on the jury, they're gonna give you every reason to excuse them because they can't afford it. So our system is broken in every way imaginable.
I picked up a flyer from Chipotle. I used it on my way back one day.
Is that where you're gonna be working?
After lunch, but it was back.
Oh, okay.
But they had a little flyer advertising hourly pay that was $3, $4, $5, $6 above what the hourly rate is we break out to people in our office. College tuition assistant up to $5,000 a year, 401k, medical, health, dental. That's who we're competing with. This, if anybody thinks that we are immune somehow to the marketplace and what's going on, to get good people, then they're living in an alternative universe.
And can I say this about public defenders? I have worked for a little while in Lexington as a prosecutor, but worked as a public defender. And the stress, I'm sure all these jobs are stressful, but the stress of having someone who you feel responsible for, and not just someone, but maybe 15 to 20 someones in a day, and take that over times 5, it is an incredible amount of stress. And I hope that as we reform our system, we will also build in more EAP for people who do this kind of work, because you are really on the front lines. You are taking on so much of the stress and burden. And we see this even at the league. Our turnover rate is higher because the level of depression and desperation in our community as it increases, we all are harmed. None of us are safe. We cannot continue to live in this boiling hot water, and we really do have to do something. And the last thing I'll say on that, as a public defender, I remember walking in and actually trying a case the day I met my client, because he had been in custody too long. And if I would have said, okay, we gotta pass it because I kind of need to get to know you a little bit. This guy's like, I wanna go home, and I did not do this. And so I had to make a decision on the spot to decide to try a case with someone I met at 9:30 in the morning. We had a 1 o'clock trial. No, I mean, that is incredible. Nobody's life, and it was his freedom. He was looking at a year in jail. We were in district court, but that's what you're faced with. And that was happening, I won't say how many years ago, when I was a little girl, and I was a lawyer, and I was gifted.
Thank you very much for being here. We are 10 minutes behind, but I'm gonna wrap up with one final thought from each of you with a question of, okay, what's step 1? What is we're talking about bail reform in the state of Kentucky. Tell me what you feel step 1 should be.
I think it's education for the public, that people need to understand that you're not trying to punish somebody, and somebody will be out until their case is decided is what they would want for their own child, their spouse, their niece, their nephew, so they should want it for everybody else.
I think we need to remember that judges should start at ROR. That is where we shouldn't be starting at $500. It's to start at ROR, and that should always be the default position. And so if you have to work your way from there, then you have to work your way from there, and you should have considered other factors. But the baseline to start should be what the law says, which is ROR. And so if we did more of that and we made that more common, I think our system would be better. In the meantime, as we actually reform and do move into a cashless system, because there is no justification for the system we currently have.
I think we're all in agreement, the current system is broken, it needs to be repaired. What I would like to see is that we take it apart and learn from what we've already seen, and that is like an administrative release. I think we can learn, or we have learned, that we can do things differently, and that we ought to take that to heart, look at various studies that have been already done on this, in this area, and make the changes that are needed.
And I would just add that I think it's really important for people to come to the courthouse, see what's actually going on. The courts are open to the public, come and see for yourself. Logging into Zoom is still an option for most courts. You can do that minimally, but come and see the different parts of the system at work, and keep having the conversation so we can make things better.
Thank you all for being here. Really appreciate it.